It's so good to see you guys. Hope you're all doing great. Yeah? Sounds good. All right. So let's begin. I'm here today to introduce to you guys the law of evidence. Okay? So I'm not here to teach you because, as my professor used to tell me, law can never be taught, it can only be introduced. It's your responsibility to expand your knowledge and your thought process on how to deal with the law of evidence. And you can always come back to me with your questions. I'm here to help. Okay? So let's dive in. So I have a question for you guys. So you can feel free to share your thoughts. There are umpteen number of legislations in our country. But in law schools, we give specific importance and we focus on certain laws and enactments. Why do you think so? Anyone? No, it's not just the restriction in time that we have during the 3 years or 5 years. No, it's not just that. Right. That's what I was thinking about as well. So, certain laws are fundamental in nature. So, they lay a foundation for other laws and enactments. Alright? Without these fundamental laws, we cannot appreciate or even understand the other enactments. So, that's why we focus on certain laws. So, such a law is our Indian Evidence Act 1872. It is a fundamental law that every law student need to know. Okay? Alright. So there are two broad principles that our legislators should keep in mind while drafting laws. Okay? So one, it should provide the greatest benefit to the greatest number of people, and two, it should cause the least harm to the smallest number of people. Okay, and there are 5 aspects that generally law talks about. 1. What should be done, and 2. What should not be done. 3. What may be done or may not be done. 4. How certain things are to be done. And 5. The consequences of doing what the law prohibits and not doing what the law mandates. So these are the 5 key aspects that all laws talk about. Alright, so let's look at each of the aspects individually for better understanding. Okay, so first, things which should be done. A husband should maintain his wife. This is common in most of the personal laws, right? So this is something that should be done, which the law mandates. And secondly, things which should not be done. Homicide. One man should not kill another man, which is pretty common across the world, right? And third, things which may be done or may not be done. For instance, writing a will. It is not a legal obligation on every citizen of a country to write a will, isn't it? So it is something that a person may choose or may not choose to do. And fourth, how certain things are to be done. Let's say a husband doesn't pay maintenance to his wife. So how is she supposed to get the relief? She has to file a petition under CRPC section 125. That is how certain things are to be done. And finally, the fifth aspect, which is one of the most important aspects, that is consequences of doing what the law prohibits and not doing what the law mandates. For instance, if one person kills another person, he or she shall be charged and tried under section 302 of IPC.
All right. So those are the 5 key aspects as to what the law should talk about. Now let's look at the consequential aspect in a detailed manner using an illustration. Here, Ajit, who is the buyer, is promised by Miss Julie, the seller, that she would deliver certain goods at a certain price within a specific period of time. But within that time, she is unable to deliver those goods, due to which Ajit is now forced to buy it from a different seller, Miss Fatima, at a much higher price, due to which he faces a huge loss. So Ajit intends to get compensated for the loss that he faced due to Julie's breach of promise. So he goes to an advocate and explains what happened. Ajit's advocate looks at the rule that is applicable in this scenario from either the laws passed by the competent legislature or the judgments passed by the Supreme Court, or, if unavailable, from the judgments passed by the High Court. Believing that the law is in Ajit's favor, his advocate goes on to file a plaint with relevant provisions and allegations against Miss Julie, thus initiating a civil suit. So, the court sends a notice to Miss Julie. Not knowing how to respond to the notice, Miss Julie hires an advocate. So, what do you call a document that is filed against a plaintiff in a civil suit? Any guesses? That's right, a written statement. So, there are generally four common scenarios that one may come across while responding to a plaint. So, in our case, scenario one, Julie admits her liability. And scenario two, Julie admits the facts alleged by Mr. Ajit, but she contends that she does not have any liability to pay compensation to Ajit because she did not breach any law. And third, Julie admits certain allegations and she denies other allegations. And scenario four, Julie denies all allegations and she introduces new facts. So in scenario one, the court does not have much work to do because Julie had admitted her liability. So the only thing that the court needs to do is to go on and pass a judgment in favor of Mr. Ajit. And what about scenario two? Julie admits the facts alleged by Mr. Ajit, but she contends that she did not breach any laws. So Julie's advocates, referring to Ajit's side of the argument, states, "Your arguments and contentions may be true, but it does not mean that you would win the case because you have not satisfied the conditions and rules laid down in the law." And Ajit's advocate would put forth his side of the arguments. And what would the court do? The court would interpret and find out the real meaning of rule of law. So it would decide which conditions should be satisfied and whether those conditions are actually satisfied or not. Since the allegations are already admitted by Ms. Julie, if the court feels that Ajit's side of the arguments are true, then it would rule in favor of Mr. Ajit. If not, then it would dismiss Ajit's suit. And moving on to scenarios 3 and 4, they are very much different from scenarios 1 and 2 because law of evidence plays a very prominent role in these two scenarios. Because Julie had denied certain allegations made by Ajit, or she completely denies all allegations and goes on to even introduce new facts. So, what does this mean? There's affirmation on one side and denial on the other. So, the court's decision would be based on the extent to which it believes Ajit's contentions and Julie's contentions. For Mr. Ajit to win the suit in scenarios 3 and 4, he has to do a lot of work. Primarily, he has to prove two things. One, he has to prove that the facts that he contended exist and the facts that Ms. Julie contended does not exist, both to the satisfaction of the court. So, who all are aware of the existence and non-existence of facts? Of course, firstly, it's the parties to the suit. In our case, Mr. Ajit and Ms. Julie. And apart from those two, it's the witnesses. So, Mr. Ajit, Ms. Julie, and the witnesses deposing regarding the existence and non-existence of facts before the court of law is what we call the process of giving evidence. Mere submission of evidence is not sufficient for convincing the court, so its authenticity must be put to test. This is done by conducting a cross-examination which is undertaken by the opposite party. And arguments are made by the advocates as to why the parties or the witnesses must or must not be believed, and based on which the court decides the existence and non existence of facts and delivers its judgment. All right, so let's look at another illustration. This is the criminal case where Alia complains about Chetan that he had committed an offense. In response, the police they file an FIR, they conduct a preliminary investigation, and they prepare the final report. So, a quick question to you guys: what is the term that is colloquially used in place of final report? That's right, it's charge sheet. Just get to know it, but don't use it. Always prefer the term final report. All right? So, these documents are sent to the competent magistrate court, and the court sends a notice to Chetan in the form of a summon or a warrant, depending upon the subject matter of the case. Upon receiving the notice, Chetan would voluntarily appear before the court, or if not, the police might be forced to arrest him. The court would ask Chetan whether he pleads guilty or he pleads not guilty for the offense charged against him. If Chetan pleads guilty, generally his plea would be accepted and the court would impose a fine or imprisonment. If he pleads not guilty, then it is for the prosecution to prove his guilt by calling upon witnesses who speak of the existence of the ingredients that make up the offense. Upon examining the oral evidence provided by the witnesses and the documentary evidence submitted by the prosecution, the court decides whether the offense is proved or not and whether to convict Chetan or not. So it is pretty crucial to understand that it is for the parties to contend whatever they want, but they should back it up with solid, relevant evidence, without which there are high chances that they might lose the case. This shows the extent to which law of evidence plays a significant role in the administration of justice and in winning a case. All right. So, how many of you think that law of evidence should have certain rules set? How many say yes? All right. And how many say no? All right. Okay. So, there are two views as to the necessity of rules for law of evidence. Okay, so one is that no, there should be no rules for law of evidence at all. And the second view is that yes, there should be definitely certain rules set for law of evidence. All right, now those who argue for not having any rules for law of evidence, what they often say is that since the key objective of law of evidence is to determine the truth, the more the court hears, there are higher chances of arriving at a correct conclusion. So, to exclude certain matters, they feel that it would hamper the court from arriving at a correct conclusion. And they state that all rules of evidence are fetters to justice. So, the best rule of evidence is that there should be no rules of evidence. This does seem like a fair argument, right? So, why do we have rules for evidence and all? So until we find the killer or until we find out who robbed the house, we should keep digging the truth by allowing all sorts of evidence from any person, which would be of help to the court in order to find the perpetrator. Even I was of a similar view when I was initially learning the law of evidence. But when I heard the other side of the argument, that is, those who argued for having rules for law of evidence, I changed my mind. Because if we have no rules for law of evidence, then no case would ever be decided, right? So let's say a crime involved 10 people, and those 10 accused bring in hundreds and thousands of witnesses and evidences to be examined in the court of law. The count actually doesn't matter, but the count would be so high if there are no rules for law of evidence. So it is only by restricting those which are very relevant and significant to the case, the court would be able to decide the case within a certain time frame. If not, it might take years together for even deciding a simple theft case, and justice would become a mockery. There's another debate as to whether the power to frame rules of law of evidence should be left to the judge or not. Let's say the judge who presides the court has the discretion to decide which matters are relevant and which are not, and which evidences are admissible and which are not admissible. Then the decisions that the court arrive would highly depend upon the patience of the judge and not law. So there are high chances of the rights of accused as well as the victims being compromised because it varies depending upon the judge, right? And and there would be no equitable justice at all. And there are high chances of judges abusing their power. This is why it is often stated that the best jurisprudence is one which leaves the least to the judge. So, how should the rules of law of evidence be? It should not be too pedantic, that is, there should not be too many rules involved. And discretion, it should not be too wide, it has to be limited. So, it has to maintain a just balance between rigidity and flexibility. So, if we look at the Indian Evidence Act, keeping these two principles in mind, it has to be said that it maintains a proper proportion of flexibility and rigidity. All right, so that brings us to the end of today's class. I hope you guys found it helpful. Please feel free to ask any questions that you have. All right, I'm here to help. And before you guys leave, I want you to write me down something. You can write it to me later through email as well. All right. So, three things that you learned today, two things that you found interesting, and one question that you have. Okay? If you are done with that, you can leave. In the next class, we'll look at why law of evidence is lex fori and the similarities and differences in law of evidence in dealing with civil and criminal matters, and a brief history of law of evidence. All right? Thank you.